Hello, I'm Graham Dale. On taking office in 1997, Tony Blair embarked on the most radical and fundamental changes in the British Constitution for some years. You were not informed or consulted, and yet these changes have profoundly affected how our nation is governed, its democracy, the primacy of Parliament, and its accountability to the people. And eventually they have come to threaten the very existence of our United Kingdom of Great Britain and Northern Ireland. Well, what did Blair do? Firstly, he introduced the Human Rights Act 1998 that incorporated the European Convention of Human Rights into British law. Until that point, human rights in Britain were never really considered a contentious issue, as we were protected by statute and common law going back as far as 1215 and Magna Carta. Blair's legislation at a stroke subjugated British law to international human rights law and created a whole new industry of human rights laws and its attendant human rights lawyers, including Cherry Blair. The immediate effect of conferring ECHR rights not only to British citizens, but to all and sundry who turn up on our shores, has been the bizarre, dangerous, and socially damaging consequences we see today. Criminals convicted of serious offences and migrants entering the country illegally can't be deported if they invoke their ECHR rights. This has led directly to the government's inability to control our borders, the significant dilution of our culture, and serious threats to our national security. Well, that's bad enough, but it's now reported that SAS soldiers are resigning in significant numbers over fears of being subjected to witch hunts by human rights lawyers, including our own Prime Minister and Attorney General in their previous lives, as our government has inexplicably extended ECHR rights to war zones. Soldiers are frightened of doing their job of protecting the nation, as they may end up being prosecuted and persecuted years down the line, just like the disgraceful pursuit of Northern Ireland veterans, whilst IRA terrorists were given immunity from prosecution letters by Blair. Secondly, Blair introduced devolved governments to Scotland and Wales, with the clear intention, in my view, of entrenching Labour's historic control over its rock-solid Celtic fiefdoms. That worked wonderfully well in Wales, where Labour has been in power for all of the 26 years since devolution. But it's been an unmitigated disaster in Scotland, where the SNP has been in power since 2007 and has since actively worked to destroy the United Kingdom. Well, after the upcoming May elections for the devolved assemblies, the SNP is likely to win again in Scotland and Plaid Cymru in Wales. We could end up with two constituent nations of the Union run by parties who share the ideology of destroying it. Northern Ireland is a special case, but even here the power-sharing legislation created by the Good Friday Agreement provides for a border referendum that could lead to Northern Ireland being absorbed into the Irish Republic. Thirdly, Blair introduced the Constitutional Reform Act 2005. Well, here, amongst other things, he created the Supreme Court to replace the appellate jurisdiction function of the House of Lords. The Law Lords were apolitical and sat as our final court of justice and of appeal. The Supreme Court, however, has been accused, rightly in my view, of political interference, judicial overreach, and undermining the sovereignty of Parliament. Blair effectively transferred lawmaking powers from our elected and accountable Parliament to unelected and unaccountable judges. A well-known example is the 2019 second Gina Miller case. Remember her? A well-publicised, well-funded and very active anti-Brexit campaigner who argued that the prorogation of Parliament at the request of the Johnson government was unlawful. The case was first heard in the High Court, where the judge agreed with the government's lawyer that the situation was not justiciable, that is, not being capable of being settled by a court of law. The argument was accepted by the judge that the right to prorogue Parliament was an established ancient prerogative and resided exclusively with the monarch on the advice of the Privy Council. There was no legitimate involvement of the courts. However, in a clear expansion of its jurisdiction, the Supreme Court ruled that the case was, in fact, justiciable, and they would decide the issue. And so, contrary to the established ancient prerogative, they decided that the Privy Council's advice to the Queen was illegal and set it aside. So now we have case law that says that the Privy Council's advice to the monarch is subject to judicial review. To me, the case was clearly politically motivated by anti-Brexit campaigners who received a sympathetic hearing from a sympathetic judiciary and was a clear case of judicial overreach. Also in 2023, the Rwanda deportation scheme was ruled unlawful by the Supreme Court because of the concept of refoulement under United Nations treaty law. Rwanda was judged to be not a safe country to which illegal migrants could be deported, as in theory, they could then be sent elsewhere where they could be subjected to ill treatment. This is the concept of refoulement. Judges have also interfered in industrial pay disputes under human rights and equalities legislation, with the most famous and consequential decision resulting in the effective bankruptcy of Birmingham City Council, with an award against them of nearly £760 million in an equal pay claim. Unfortunately, I don't have sufficient time here to comment on the constitutional changes introduced post-Blair by Gordon Brown's Equality Act 2010 and the Constitutional Reform and Governance Act, also of 2010, but they are significant. In conclusion, we're living today with the consequences of Blair and Brown's constitutional vandalism, with the United Kingdom closer to irreparable fracture than ever before, in a society riven with division and sectarianism, and a left-leaning, politicized judiciary. I'm left with two questions. Why did they do it? And who benefits?